vast area of high seas, with 7 states in its boundaries. Around 30% of international trade and 50% of India's global trade passes through the South China Sea. There are unoccupied islands, rocks, islets, banks, and rocks present in this area, which are mostly underwater except during low tide. South China Sea after 20th century has become a significant geographical water body. Such developments is visible through physical occupation taking place in scattered islands of archipelago called Scarborough Shoal by littoral states in 1970. Sir, this archipelago is mostly barren, uninhabitable and contains little land resources. Therefore, this archipelago can be considered under Article 121 subclause 3 of UN rules under regime of islands. South China Sea provides for vital human food security and provides 80% of the diet as well as 25% of the protein needs to about 600 million people in the littoral states. Further, there are about 11 billion barrels of oil reserves and 190 TCF of natural gas reserves. The respondent Qinna is a vast mainland. It has been an economic, military, naval and air powerhouse and a nuclear power of the past 30 years. Sir, may I start with arguments? South China Sea provides natural resources and free international trade since the immemorial time to its littoral state. Therefore, it is a dire necessity to maintain balance of power through tranquility and by encouraging equitable distribution of resources present in seabed and continental shelf. Sir, there are certain rights and duties of coastal states in the littoral sea. The Convention of UN rules discusses certain rules to enforce these rights and duties, which are consistent with the rules of international law in rights and duties, conservation of living resources of the territorial sea. The clause 4 clearly states that UN clause 2 does not allow any artificial islands, will not include in any state territory artificial island with heavy military exercises. The preparation for war is threat to peace and is a violation of our UN obligations and is threat to peace under the customary international law. The dispute we have with Qinna is solely governed by convention. We assert that the law enforcement activities of Qinna is a violation of its obligations under the Convention of International Regulations for the Prevention of Collision at Sea and UN. The second issue is that what impact does Qinna's claim of sovereignty has on the other littoral states, and does the convention guarantee any fishing or navigation rights to the states? South China Sea is providing fertile fishing grounds for us, the right of fishing for fishermen and a smooth route of navigation for the nations of the region and the rest of the international community. This could not be taken away by claim of sovereignty by any single state. It is a violation of well-settled rules of customary international law. There are certain provisions in Article 1 of United Nations Convention on the Law of Sea, that is UN clause, which relate to fisheries, protection and preservation of the marine environment, marine scientific research and navigation. In the case of Costa Rica versus Nicaragua, as regards subsistence fishing, the court found that fishing by the inhabitants of the Costa Rican bank of the same UN river for subsistence purposes from the bank must be respected by Nicaragua as a customary right.
How military aggression by Qinna puts the threat to sovereignty?
The issue here is about dealing with residual rights, not attributed to any one specific authority and control. The new and future uses of the sea made possible by development of science and technology and the maritime military uses are not contemplated in the convention, but it only attributes provision in relation to traditional practice by military power in the high sea. Qinna's regular military, naval and air exercises conducted in these waters is a threat to peace of all adjoining states and it is a violation of our sovereignty. Qinna had developed its military and economic power in the area in order to use unoccupied islands and are developing artificial islands by merging some scattered group of islands. Therefore, Qinna has infringed certain human rights of the national of our countries and distributed our sources of livelihood.
How Champanam has a better claim to sovereignty than Qinna?
Qinna's claim of sovereignty is violation of other state sovereignty and right conferred by international ocean gulf which is shipped through its route. These shipping routes would become vulnerable to blockade which could slow down Qinna's mobilization. Qinna being a nuclear power for the past 30 years may provide separate sea lanes for ships carrying nuclear or inherently dangerous or noxious substances. The territorial state may also take steps to prevent passage which is not innocent. In the interest of protection of its security, it may with prior notification may temporarily suspend the innocent passage without discrimination.
Okay. Why China's claim on this archaeology is not a valid claim?
Scarborough Shoal is a large reef in the northern part of the South China Sea. Most of the reef is below water at high tide, but there are 4-6 rocks that are islands under Article 121 because they are above water at high tide. Scarborough Shoal cannot support human habitation, so it is not entitled to an east and continental shelf of its own. China's only possible claim to water beyond 12 nautical miles from the reef is that they are within the 9-dash line. The islands on Scarborough Shoal are rocks within Article 121 subclause 3 and not entitled to an east and continental shelf of their own. The area in dispute between Qinna and Champanam would be limited to the rocks themselves and the 12 nautical mile territorial sea adjacent to them.
How can,
Yes.
how can you claim that any particular territorial sea comes under the sovereignty of nation?
Qinna has unlawfully claimed maritime entitlement beyond 12 nautical miles from these features and has unlawfully interfered with the exercise by the Champanam of its right and freedom in the maritime space surrounding the Scarborough Shoal. The geographic features in the KIZ that are currently occupied by Qinna do not meet the definition of an island as set out in the Article 121 subclause 1 because they are not naturally formed areas of land above water at high tide. Champanam argues that such features are not subject process of codification of the law of the sea expressed its preference for them, territorial sea in the place of territorial waters or maritime belt. Since then, the term territorial sea is en vogue. Now, I behalf on the petitioner side, humbly request before the Honorable International Court of Justice to permit injunction of stay order to Qinna to stop further activities on the disputed maritime zone. Qinna can only claim rights to maritime space in maritime zones measured from land territory, and that claims for the 9-dash line and not consistent with UN rules, and to keep the international waters free and open to all bordering states so they can utilize the resources that is available to all. That's all.
I would like to take the permission of Lordships of International Court of Justice to present my arguments in favor of respondent Qinna. Your Lordships, Qinna is a superpower and a permanent member of United Nations Security Council. The dispute we have with Champanam is solely governed by the convention. Our maritime features are properly characterized as islands, rocks, low tide elevations, submerged banks, and we claim the maritime right based on the convention. Your Lordships, I further would like to add that respondent Qinna have been exercising military, naval, air exercises on that area since long and continuous period. Therefore, the respondent have better claim to sovereignty than the other countries who do not have any reasonable jurisdiction over the resources of South Qinna Sea. Your Lordships, respondent imports around 80% of its oil from the Persian Gulf, which is shipped through its route. These shipping routes would become vulnerable to blockade, which could slow down Qinna's mobilization. Your Lordships, Article 59 of UN Convention on Law of Sea states that in cases where this convention does not attribute rights or jurisdiction to the coastal state or the other states within the exclusive economic zone, and a conflict arises between the interests of the coastal state and any other state, the conflict should be resolved on the basis of equity and in the light of all the relevant circumstances, taking into account the respective importance of the interests involved to the parties as well as to the international community as a whole. Further, Article 59 must be read with Article 55, which defines exclusive economic zone. It defines exclusive economic zone as having a sui generis legal status, as well as Article 58, Clause 1, referring to various freedoms of the high seas, including those rights that are compatible with the other provisions of this convention. Your Lordships, the issue here is about dealing with residual rights, not attributed to any one specific authority and control. These are related to the new and future uses of the sea made possible by the development of science and technology, and the maritime military uses not contemplated in the convention but traditionally practiced by military powers in the high seas.
Okay. What are the historical claims put by the Qinna, and how does the historic claims give way to their claim to sovereignty?
Yes, Your Lordship. Your Lordship, Qinna claims that South Qinna Sea belongs to Qinna because it is a major bordering state of South Qinna Sea. The historical activity goes back to 1947, when Chiang Kai-shek's nationalist government drew the 9-dash line on Qinna's maps of South Qinna Sea. In 1935, Qinna made his geographical map, which has 11 dash lines consisting of South Qinna Sea on the map. And in 1979, it declared 9 dash line, which also consists of South Qinna Sea. It is not uncommon for states to invoke an ancient, original or historical title, particularly in Asia, where traditional boundaries play a significant role. In this regard, I would like to quote a case which is for the title over Pedra Branca. The two disputing nations in this case were Malaysia and Singapore. Petra Branca is a rocky insular land which is half the size of a football field. In this case, the ICJ held that while Malaysia had the original title on the basis of historical title as of 1844, it concluded that commencing from the construction of a lighthouse by the United Kingdom, who colonized Singapore at that time, on Petra Branca in 1844, especially by reference to the conduct of Singapore and its predecessors, taken together with the conduct of Malaysia and its predecessors, including their failure to respond to the conduct of Singapore and its predecessors, that by 1980, sovereignty over Petra Branca had passed to Singapore. This case of sovereignty over Petra Branca between Malaysia and Singapore illustrates two important points. First, states can claim historic rights to small, uninhabited or even seemingly uninhabitable maritime features. Secondly, it is clear that a mere assertion of title to an island or insular land feature on the basis of historical rights or mere control is not enough. It has to be supported by continuous and uninterrupted, and one might add unopposed, exercise of sovereign functions in proportion to the nature of the maritime feature, particularly in the face of the adverse claim or claims to title. Champanam appears to distinguish historic rights which are not referred to in any of the provisions of United Nations Convention on Law of Sea from historic waters or historic bays, which are referred to in Article 15 and Article 10. It may be noted that they are all included in the right of a state party to UN clause to exclude any dispute concerning them from UN clause. Compulsory procedures of dispute settlement, including compulsory conciliation procedure, if it necessarily involves the concurrent consideration of any unsettled dispute concerning sovereignty or other rights over continental shelf or insular land territory. Your Lordships, respondents' activities in the South Qinna Sea dates back 2000 years ago. Further, Qinna was the first country to discover, name, explore and exploit the resources of South Qinna Sea, and the first to continuously exercise sovereign powers over them. Following the end of World War II, stating that respondent actively resumed its activities over the area, and by 1948, after conducting necessary surveys and renaming the islands, it was able to publish an official map which displayed a dotted line in the South Qinna Sea. Respondent's nation, Qinna, was founded on 1st of October 1949, had maintained sovereignty of respondent over the South Qinna Sea, and officially pronounced as part of its 1958 Declaration of the Territorial Sea and 1992 Law of the People's Republic of Qinna on the Territorial Sea and Contiguous Zone, that the territory of Qinna includes, among others, the Dongsha Islands, the Shaisha Islands, the Zhongsha Islands, and the Nansha Islands. Your Lordships, it is very important that the threat to the international free trade by sea and the development of regional arrangement created by 4 major international countries to protect the international free trade in South Qinna Sea may endanger peace of the world and be a cause of war. They are carrying military exercises and are preparing for war. This is a crime against peace and is a violation of UN obligations. International trade by the major trading states in the South Qinna Sea have only been proving detrimental to the resources present in the sea. The actions of the 4 major international trading states have only exploited the area for the purpose of generating profit. Such greed for profit will only result in sooner exhaustion of resources. The 4 international trading states have been monopolizing the sea trade route. They are yet considering the South Qinna Sea under Freedom of Seas Act which was a doctrine created merely to establish industrial control over the seas. The previous laws were specifically reorganized to suit the present needs and to provide equitable distribution of resources. Such acts in the name of protecting free trade are nothing but another way to incite Qinna. The trading states have been supporting the littoral states only so that they can keep its army in the Qinese outskirts. On the point of Scarborough Shoal raised by the Learned Council, I would like to say that respondent claims that in 1935 they had set up a map verification committee which declared sovereignty over 132 islands, reef and shoals in the South Qinna Sea. When Scarborough Shoal was listed as a part of what Qinna today calls Zhongja Islands. Qinese authors argue that since Qinna considers Scarborough Shoal to be a part of Zhongja, when Qinna declared sovereignty over Zhongja in 1951, therefore, this declaration implicitly includes Scarborough Shoal.
So, does the dispute qualify as dispute under UN clause?
Rights provided under UN clause are exhaustive, Your Lordship. It was argued in the case of Republic of Italy through the ambassador versus Union of India and others that if it could be assumed that the rights asserted are beyond those indicated in Article 56 of UN clause, such conflict must be resolved on the basis of equity and in the light of all circumstances. There are no provisions in UN clause on how to determine which state has a better claim to sovereignty over a disputed territory. UN clause only sets out what maritime zones can be claimed from land territory, as well as the rights and jurisdiction of states in such maritime zones. The law enforcement activities of Qinna, which the Champanam assert as a violation of its obligations under the Convention for the Prevention of Collisions at Sea and UN clause.
What is Qinna's claim to sovereignty over South Qinna Seas?
Yes, Lordship, Qinna has sovereignty over the islands and other insular features and has sovereign rights and jurisdiction in accordance with UN clause over the waters and seabed and subsoil adjacent to those islands and insular features. Second, it preserves Qinese historic rights in fishing, navigation and such other marine activities as oil and gas development in the waters and on the continental shelf surrounded by the line. Third, Your Lordship, it is likely to allow for such residual functionality as to serve as potential maritime delimitation line. Your Lordship, the decisive question for the present case is whether a state can acquire sovereignty by appropriation over a low tide elevation situated within the breadth of its territorial sea when that same low tide elevation lies also within the breadth of the territorial sea of another state. International treaty law is silent on the question whether low tide elevations can be considered to be territory or not. Nor is the court aware of a uniform and widespread state practice which might have given rise to a customary rule which unequivocally permits or excludes appropriation of low tide elevations. It is only in the context of the law of sea that a number of permissive rules have been established with regard to low tide elevations which are situated at a relatively short distance from a coast. Taking support from the International Court of Justice in United States diplomatic and consular staff in China, that there are no grounds to decline to take cognizance of one aspect of a dispute merely because that dispute has other aspects, however important. The issues of interpretation and application of the convention in this case are integrally linked to the issues of sovereignty and maritime delimitation, even if they are two separate parts of the same exercise. The sovereignty of a coastal state enjoys over a territorial sea is significantly different from the sovereign rights and exclusive jurisdiction it has over the exclusive economic zone. As noted, the principle of exclusive economic zone struck a perfect compromise between coastal state and maritime powers by establishing an area with a special legal status different from that of territorial sea and of the high seas. The principal aim of negotiators was to ensure that the use and exploitation of the oceans would benefit all nations in a way that was fair. This objective could only be accomplished by accommodating the specific interests of the two main group of countries represented at the conference. In other words, exclusive economic zone is not territorial sea with some exceptions in favor of third states, not the high seas with some exceptions in favor of the coastal states. As for the conditions to which the implementation of exclusive prescription is subject, the judges noted that we know that there are 4 accusative prescriptions. These are: first, the state which relies on it must exercise authority over the territory concerned, which implies, on the other hand, the effective exercise of the attributes of sovereignty and, on the other hand, the sovereign intent. Second, the exercise of authority must be peaceful and continuous. Third, the exercise of sovereignty must be public, which is to say visible, an essential condition for establishing acquiescence through failure to respond of the state holding the original title. Fourth and the last, the exercise of authority must continue in the conditions just described for quite a long period. Although it did not mention prescription, as we have said, the court would not seem to have intended to apply criteria other than those in the present case. Judges Qinna and Abraham also noted that one idea unmistakably emerges from the jurisprudence that there is an original sovereign, no exercise of state authority. However, continuous and effective can result in a transfer of sovereignty if it is not possible to establish that in one way or the other. The original sovereign has consented to the cession of the territory concerned in its transfer to the state, having de facto exercised its authority. In its judgment, the court declined to attach legal effects to the acts of sovereignty performed by Nigeria in the disputed territory, since, as it said in substance, Cameroon had an earlier title to sovereignty and it could not be regarded as having acquiesced to the transfer of that title to Nigeria. In the case of Nicaragua versus Honduras, the court found that sovereignty over the islands belonged to Honduras, as it had shown that it had applied and enforced its criminal and civil law, had regulated immigration, fisheries activities and building activities, and had exercised its authority in respect of public works there. As for the delimitation of the maritime area between the two states, the court found that no established boundary existed along the 15th parallel on the basis of either uti possidetis juris or a tacit agreement between the parties. It thus proceeded to determine the delimitation itself.
Can you tell us, does Champanam have right to claim maritime entitlement?
Yes, Your Lord. Your Lordship, entitlement is a broader concept than a claim which is a demand based on what the subject considers as its rights under law. Entitlement could be seen as a right in favor of one party, objectively determinable and arises after the settlement of conflicting claims. Entitlement in that sense is an accrued right as opposed to a claim which requires judging and deciding upon merits. The Champanam memorials appear to use the term maritime entitlements more in the sense of maritime claims. Throughout this presentation, wherever the term maritime entitlement is used, it is employed with the understanding that it refers only to claims and not to accrued rights. It is entirely a different matter where different types of entitlements or rights accrued to two or more states could come into conflict. For example, the exercise of sovereign rights or entitlements by a coastal state in its exclusive economic zone could come in conflict with the entitlements of third states in respect of the exercise of the freedom of the high seas. Now, Your Lordships, I, on the behalf of the respondent side, would humbly request before the International Court of Justice to permit, firstly, in accordance with the provisions of the UN clause, the People's Republic of Qinna shall enjoy sovereign rights and jurisdiction over an exclusive economic zone of 200 nautical miles and the continental shelf. Secondly, Qinna will effect, through consultations, the delimitation of boundary of the maritime jurisdiction with the states with the coasts opposite or adjacent to Qinna, on the basis of international law and in accordance with the equitable principle. Thirdly, Qinna reaffirms that the provisions of the United Nations Convention on the Law of Sea concerning innocent passage through the territorial sea shall not reduce the right of a coastal state to request a foreign state to obtain advance approval from the coastal state for the passage of its warships through the territorial sea of the coastal state. Under Article 298 of UN Clause, the government of the Qinna does not accept any of the procedures provided for in Section 2 of Part 15 of the Convention with respect to all the categories of disputes referred to in Para 1A, B and C of Article 298 of the Convention. Qinna, being a vast mainland, has a huge population to feed. Therefore, the claim of sovereignty over the South Qinna Sea is only an extension to the cause of fulfilling the needs of the people. The petition that is instituted by Champanam before the Honorable International Court of Justice is just a perpetuating act, whereas the reins of the whole case are controlled by one of the four major international trading states. And it is just another example of how an imperialist nation uses a weaker nation for furthering its own case. It is stressed that we do not see the success on submissions would have effect on Champanam's sovereignty claim and accepts that the Champanam has initiated these proceedings with the entirely proper objective of narrowing the issues in disputes between the two states. Thank you.
Your Highness, the military, naval and air exercises over the South China Sea is violating the international laws and US laws. It is threat to peace of littoral states as is a clear sign of God. There is no strong base of claiming sovereignty on South China Sea and their historical claims are baseless. So I request the Honorable Court to order injunction on these activities and to keep the international water free, that's all.
The International Court of Justice, having regards to Article 48 of the Statute of the Court and Article 54, Paragraph 1 and 61, Paragraph 1 of the Rule of the Court, having regards to application filed is registered to the court on 16 September 2022, whereby the Republic of Qinna instituted proceeding against Republic of Champanam. So, we have, after hearing both the parties and discussing on the issue of law, we have decided to injunction on the Qinna to stop further activities on the dispute maritime zone. Respondent had violated UN Clause Law 2nd. Respondent over exceed the power of the sovereign state. So, to provide safety to the fishing activities which take place in South Qinna Sea, Qinna can only claim right to maritime space in maritime zone measured from the land territory, including islands. And the claim from the 9-9 are not consistent with UN clause. And to avoid the threat to peace which is engaged by the opposite trading nation by the trade activities free international trade. To keep international water free and open all boundaries nation so that can utilize the resources that is available to all. Respondent military exercise causes a major concern to waging war, thereby harming peace and harmony. Applicant request for the free trade in the South China Sea route is at war earlier.